Hey guys, how's everybody doing tonight? So we are here to talk about probate. I am so not used to using a mic, so just bear with me. Eventually I'm sure I'm going to get used to it. So at first when I came here, I thought the goal was to teach you guys about probate so that you wouldn't get caught in any of the pitfalls of probate. But then I asked Bryce over there, hey Bryce, what do you think everybody wants to hear about? He's like, well yeah, they want to know how probate can help them make money. I'm like, okay, so in my mind that means that if you guys have more knowledge than the next realtor about probate, you're more likely to get the listing. Would you say that's probably true? Okay. So I guess what we're going to do is we're going to talk about the pitfalls of probate, and that will essentially give you inside information about probate so that you have that knowledge to get those listings. How many of you guys have been involved in probate? Raise your hands. Okay. So the first thing when you scope out a property, you need to find out who really owns that property, right? So if you meet with someone who says, hey, you know, this was my grandmother's property and I'm her heir, you know, don't take their word for it. Definitely start asking questions about, well, you know, who else might be involved. You know, of course, don't say too much to freak them out, but keep it in the back of your mind that they might not be the actual owner. And they may not be the only owner. What we have seen in practicing in the world of probate is heirs love to forget about other heirs. They may have a brother they don't like, and sometimes it's intentional, and other times it's not intentional. Most people don't understand who the actual heir is when somebody passes away and they don't have a will. They don't understand what's called the laws of intestacy. So if somebody ends up dying and they don't have a valid last will and testament, Florida has a default rule of who takes. And that is called, they're called the laws of intestacy. Intestacy means to die without a will. When you have a will, it's called testate. Dying without a will, intestate. So Florida has that default rule that's all spelled out in the probate code of who the heirs are if someone dies and they don't have a will. So then the next question is, well, okay, if there is a will, does that mean automatically the people named in the will are the heirs? No, the will's got to go through probate. So even if someone dies and they have a will, every will in the state of Florida must go through probate in order for it to be valid and for whomever is listed as a beneficiary to actually take an interest. Does that make sense to everybody?
Yes.
Okay. So we're going to continue talking about probate, and then we're going to touch on estate planning at the very end, because as a hint, estate planning avoids probate. So let's say, and we're going to first go through the laws, like how it would work in a situation where there is no will. So you meet with the family and you find out, okay, it's for sure that the person who owns the property passed away and they're no longer with us. And then you meet with the family, and at that point in time, it's not a bad idea to reach out to the probate lawyer. Right then and there, I would suggest reach out to the probate lawyer, because the probate lawyer is going to work with you to make certain that, number one, the family is telling the truth, because we've got ways of skip searching people and finding out who the real heirs are, or asking questions to find that information out. So one common thing that occurs is somebody passes away, and let's say they're survived by 3 children, and one of their children passed away and left children surviving. Well, those grandchildren are involved. They step into the shoes of their deceased parent, and they're also heirs, and you have to deal with them. So, and at that point in time, guess what we're all doing? We're crossing our fingers and toes, trying to hope to God that they're not minors. Because guess what happens if they're a minor? Well, that triggers a guardianship proceeding, guys. So I want you guys to know all these things so that you're aware and you're ready for this, right? So keep that in mind. Let's say somebody passes away, they don't have a will, they're survived by 3 children and they had 1 child, and this is an example, who ended up dying and left children surviving. So all of those people, the 3 surviving children and then the children of the deceased child, those are all your intestate heirs. Now, just to back up, we're still under the subject of who owns the property, who are these heirs. Let's say that somebody ends up passing away and they have a surviving spouse. Well, if that surviving spouse had children from another marriage, or the decedent has children that are not the surviving spouses, the surviving spouse does not take 100%. So if it ends up being homestead property, there is a very specific set of laws that apply. If it's not homestead property, we're under a different set of laws that apply. But I just want you guys to know that spouse, if he or she ends up having kids of their own that are not the decedents, or the decedent had kids which don't belong to the surviving spouse, the surviving spouse is not your only heir, okay? So then let's talk about the situation where there is a surviving spouse and they have the same children with the decedent, they share the same children. Well, then your heir is the surviving spouse. And if she or he is elderly, I would absolutely make certain that there is a valid, durable power of attorney in case that person loses capacity. Because guess what? Let's walk through a situation where you've got the deal of a lifetime, and you have identified the heir, and it's a surviving spouse. She is 85 years old, and she seems to have pretty decent capacity, but maybe not great. And then, something happens and she loses capacity. What happens to your deal? Well, it's going to be put on hold, because guess what is going to have to occur if there's no durable power of attorney? Guardianship court, which is the worst court in the world. Probate court is bad, guardianship court is worse. Making sense, guys? So, and this is where you can develop some rapport and some trust with the family to be like, hey, by any chance does mom have a valid power of attorney? And they'll say yes or no. And then you want what you do when you get a copy of that thing, send it to the probate lawyer, who probably also practices in estate planning and can tell you whether or not it's valid under Florida law. Okay, guys? So that's how you protect that deal. So, another misconception that people have is that property cannot close until the probate's over. No, that's ridiculous. That's not true at all. We get the authority from the court to close long before the probate is ever over. It's just a separate petition that the probate lawyer has to file with the court with some paperwork, and the judge will approve the sale. So you guys don't have to worry, probates can take a long time to close. Like for the probate to close, but your real estate sale can close long before that occurs. Make sense? So if you ever are working with a probate lawyer and they tell you that, it's not true. When it comes to probate, if there is a will, like I said before, the will has to go through probate. It has to be executed according to Florida law, and the probate lawyer will check the will to make sure that it's valid. And in that case, you do not need court authority to sell the property, because a will a properly drafted will have a provision in there saying that the personal representative, which is Florida's term for executor, has the ability to convey real property. So if there's a will, and this is one of the pluses to having a will, you don't need that extra court petition in order to sell the property. Does that make sense? Okay. So a will overrides the laws of intestacy, because in a will you can say who your beneficiaries are, and they're not necessarily the same people as your heirs. And Florida is a little different than other states. I'm also licensed in New York. Florida doesn't, if someone dies and they have a will, and let's say they end up naming 2 of their kids but not the third, that third child does not need to be notified under Florida law. So, which is Strange, because you think they should have a chance to contest the will, but Florida doesn't require it. So one of the things with probate and with what you guys are doing as realtors is always whenever we're dealing with a probate and we know that real property is involved, that and it, you know, the family wants it sold, we always try to opt for something called a summary administration. So in the world of probate, there are two main forms of probate in Florida. One is called a summary administration, and the other one is called a formal administration. So a summary administration can be done, and it can be, we can turn those babies around in less than a month, sometimes 2 weeks. I think my quickest was 3 days, actually, and that was courtesy of Judge Janesk in St. Johns County. With a summary proceeding, if someone has been deceased for longer than 2 years, no matter how much the property is worth, it qualifies for that summary proceeding. Okay, so if the person has been deceased for longer than 2 years, no matter how much money is involved, it's summary proceeding. That is the proper way to go. Okay, make sense? If somebody has not been gone for that long, and let's say there's only a homestead involved, and the value of the homestead does not count towards the value of the estate, because there's this little law in Florida that says if the value of the estate is over $75,000 and the person hasn't been dead for 2 years, you're stuck doing a formal administration if it's over that $75,000. However, with that being said, homestead does not count towards that $75,000. It's exempt property. So even though you need to deal with probate in order to get a homestead property out of the deceased person's name into the name of the heirs, the value of the homestead does not count towards computing the value of the estate in order to see if you're stuck doing a formal administration. So remember that. So sometimes we'll even do this. If we know that the rest of the estate is a mess, meaning there may be a ton of creditors, or we're not really sure what the other assets are and we really want to get this property closed, we'll open the summary proceeding and get that done when it comes to the homestead, and then reopen as a formal. That way we get the property sold, you guys are taken care of. And we're always very cognizant, and the judges are very cognizant of how this real estate market is doing. We do not want the potential sales price to plummet because a property was stuck in probate. And the judges are very good about considering that, right? So we will do our best to get that property sold, and then let's say there's other things that need to be addressed, we can reopen the estate. You guys are out of it. It's just between the family and the probate lawyer at that point in time. Make sense? Okay. So when it comes to, like I said, the best way to do a probate, and if it can be done, is a summary administration. With a formal administration, I mean, our goal at that point in time, if we have to open one, is to get the property, is to get the court, if needed, if there is no will, to get the judge to sign off and get that thing sold. And then the rest of the probate can be addressed between the family and the probate lawyer, and you guys are on your way. So do you guys understand homestead property versus non-homestead property? Does anybody have questions on that? Liens. You guys, so with liens. So let's say somebody ends up dying and they have a ton of credit card debt. Is that going to affect title on the homestead property? The answer is no, it will not. What about if there's an actual IRS lien that has been filed? Will that affect? Yes. I see Tammy saying yes. Yes, it will. The IRS has to be dealt with. We don't like dealing with the IRS because they're very, very slow and unorganized, but they have to be dealt with. And it's not the end of the world, because once we get a purchase and sale contract, we'll have the personal representative sign over a power of attorney to us so we can get the payoff amount. And then that's just built into it's built into the sale. Okay, guys? So, and I'm trying to think of any other things that you need to know about. We addressed that it's imperative for you guys to know who you're actually going to be dealing with, as far as, you know, who the interested parties are. Yes, Tammy?
Pardon me if I ask a slow question. You're so smart.
Well, I'm going really fast too. I talk fast.
So has to be maybe dealt with in the will, other assets and things, and it doesn't hold up the sale of the property. Kind of what we were talking about before, if there's a will and they name who's the beneficiary, the proceeds of the sale, even though the sale isn't being held up, how do the proceeds differentiated?
I'm going to go through an example we have right now, but there isn't a will, but it should address the question.
Okay.
So right now, I have a case where a gentleman, he was driving his motorcycle to meet his daughters for dinner. He is survived by an 18-year-old daughter and a 22-year-old daughter. He didn't make it to dinner. Somebody ended up T-boning him, and he died. He has a lot of debt, tons of debt, but he has a homestead property that's worth pretty good amount. No will, but the homestead heirs are going to be the two daughters. He wasn't married when he died. And there is a ton of creditors, guys, that have filed claims in this estate. The creditor period, so in probate, and it's great that you asked this question because now we get to talk about the creditor period. So in a formal administration, and this is a formal proceeding because we know that he has a lot of creditors and the judges really don't like it when we try to lie about that, so we just don't. So we had to open it as a formal administration. And I knew they'd be filing claims, and boy, are they ever. The creditor period is, so let's say somebody gets appointed as personal representative, they have letters. The probate attorney right then and there needs to file a notice to creditors in the Jack Staley record. That thing has to run for 90 days before the creditor period is over. We want to sell this real property ASAP. It is under contract. Our creditor period isn't going to be over until, I would say, September, late September, and we want to sell it before then. So what we're going to do in our petition to the judge to sell the property is we say, Your Honor, please bless our petition to sell the property, but the proceeds until this creditor period is over, even though it's homestead, the judges say that the creditors still they have to have their day in court too because of due process. So the net proceeds, you guys will get your commission, will go into my attorney IOTA account. That's my attorney trust account that's monitored by the Florida Bar. And once the creditor period is over, then we will file another petition with the court to ask for a distribution of those proceeds. But you guys are, so does that answer your question, Tammy? So even if there's a will, it's the same thing, guys. If that creditor period isn't over, then we will just tell the judge, in our petition, that the net proceeds will hang out in our IOTA account. Okay?
The executor or whatever that we're doing, they're not going to immediately get their money because there's still this time when the creditors may want their piece of the pie.
So the personal representative? Well, they're not going to get their, because they're entitled to commissions as well. They're not going to get that until probate's ready to close and until we see who the creditors are. But I wouldn't say we don't necessarily make them wait until the end of probate, and I'll tell you why. Because Florida has this thing called a priority of claims of which creditors get paid first, and before any creditors get paid, the personal representative is allowed their 3% compensation.
Well, I mean, as far as family members.
Oh yeah, so distribution to heirs, they're not going to get anything until the creditor period's over. That's right. So once the creditor period is over, and that would be towards wrapping up the probate. So once the creditor period is over, let's say we're ready to close the probate, well then we're going to notice all the creditors by way of, you mail them your closing paperwork, electronic return receipt requested, and they've got 30 days to file an objection to that. But that's more so you guys are out of the scene by then.
Right, but as somebody who's trying to help reassure them that we're going to take good care of them, we're not going to just take our commission and bounce.
Well, that's where you have a meeting so the probate lawyer can explain that to them. Yeah, you guys don't be very careful of mentioning anything to do with giving them legal advice. Don't give them legal advice, because then they'll start saying that, well, the realtor told me this, and then the probate lawyer's gonna be like, what? Who's this realtor? Giving them legal advice. And then it makes our job more difficult because people get very confused. So my advice is this: if you guys are dealing with a property that involves probate, have a joint meeting with the family and the probate lawyer. Hopefully the probate lawyer will let you come to that meeting. I don't see a problem with that. And that way everybody's on the same page. Okay? Make sense? Okay. Yeah, don't make your job more complicated than it is. Your job is to get that listing and get the most money for the family. And to recommend a title company that's really good, because bad title companies mess up all sorts of stuff. So be mindful of the title company that you're working with. Okay? I can't tell you how many title searches I've read that they actually, for some reason or another, don't include all the liens that have been filed. So a good probate lawyer will also do their own due diligence on title. And some of the firms actually have their own title company. I don't, but I always make sure that I read it very carefully and I do my own search, just to see if there is something out there that was missed. And sometimes it actually does happen. It shouldn't happen, but it does. And the other thing that happens with title searches, they mess up the legal description quite often. And the legal description, guys, for the real property is not what you see on the property appraiser's site, but it's what you would actually see on a past recorded deed. But that's more of, you guys can take a look at that if you want to, because something like that could end up delaying if it depends, but that is more of a title company thing, and I don't want you guys worrying about more than what you need to worry about. Really, at the end of the day, it's to let them know, hey, listen, because most people think that they cannot sell property until probate is over. And a lot of people think it takes 2 years to close an estate. So what you need to let them know is, no. Mm-mm. We can get this thing sold before probate actually closes. Yes.
I have a question.
Sure.
I'm a realtor, but anyway, let's say, a property owner dies and he has a multi-property. So now
Here,
the property goes into...
I'm going to have you,
court.
do you mind doing, so everybody can hear.
I say, let's say, there's a property owner and he has a multi-property, like 4 families.
Okay,
And-
multifamily property.
Yeah, multi-family.
Investment
and
property,
he
perhaps.
dies. He
Okay.
dies. So now, he doesn't have a trust, so now the property goes into probate court. Can the property still be rented out, or it has to be vacant?
I'm going to answer you. The property, so here's the thing. My advice is keep it rented if that ends up being the best situation with all things considered. But yeah, so technically with a multifamily or any type of investment property where there's tenants, it can absolutely be rented through probate. The only time that would get a little bit messy is if it would be better for the property to be sold. So let's say, and this is where, it's a great question.
How about if it's going into a market?
Like the market is getting, so like, if
the family, like the son, the daughter, reach out to a realtor, but the property is in, probate court.
Mm-hmm.
Can it still be rented while they're reaching out to a realtor?
Yeah, but that's where you need to make sure the lease agreement with the tenant is month by month.
Got it.
Yeah, don't do a year.
And is every state different?
Oh, I can only give you legal advice on Florida and New York. But Florida and New York, yeah, you can rent, the personal representative has the authority to rent investment property. But this is where the lawyer would advise them month to month, guys. Don't do a year. After probate, and this is where, really so when it comes to real property, if it's homestead, it'll eventually vest in the homestead heirs, and then whatever they decide between and amongst themselves is what happens. And if they don't decide, well, then they need to go hire a lawyer and duke it out, and that's where you get into partition proceedings.
Yeah.
Okay.
So that helps, but what about for all of us that are actually our homeowners and stuff? What do we do to protect our families to make things easier so when unfortunate things happen to us, what do we do for that?
So guys, guess how you avoid probate? Starts with an E. Estate planning. Estate planning avoids probate entirely. And so let's talk about real property. So let's say you have real property and you know that when you die, you want it to go to your kids, and you don't want a trust. Well, there's a special kind of nifty deed called a ladybird deed. So you go to your friendly estate planning attorney, let them know, hey, listen, I don't really want a trust. Because trusts are expensive, they're an investment. They're not as much as probate, I'll tell you that. So a ladybird deed, who's heard of a ladybird deed? I want everybody, everybody's going to be raising their hand soon because I'm going to tell you all about them. So the technical term is an enhanced life estate deed. In Florida, we like to call them ladybird deeds. And what it means is this: the deed is prepared and recorded while you're alive, but it says that upon my death, the property goes to my children, Jessica and Mike, right? So while you're alive with this ladybird deed, that property is yours. It's enhanced because if it's sold, you get all the proceeds. And technically, even though lots of title companies these days are being difficult, technically you should retain the full ability to sell that thing without those remainder beneficiaries, the children, having to sign off. Now, a lot of title companies these days are requiring remainder beneficiaries to sign. I don't agree with it. Usually in that case, we'll just deed it back to the parent if the kids don't, if they don't want the kids signing. Some families it really doesn't matter, but technically with the true spirit of a ladybird deed and why it's an enhanced life estate deed is that the grantor gets, if it's sold, gets 100% of the proceeds and also doesn't need anybody's permission to sell it, right? Or rent it or do whatever they want with it. Yes.
What if you have a spouse?
Well, so let's go back to who the original deed record title owners are. So if it's you and your spouse, how it would work is like this. It's a kind of like a joint ladybird deed where it says that upon the death of the last of you, it goes to the kids. Now, or whomever you want it to go to, it doesn't have to be your kids. So the reason why it's enhanced, and I keep on saying enhanced, Florida and Texas are the only states that have these types of life estate deeds. In New York, they do not have an enhanced life estate deed. They just have a plain vanilla life estate deed. And what that means is if the grantor sells it or the life tenant sells it while they're alive, they don't get to keep 100%. It's based on IRS actuarial tables, but the remainder beneficiaries get a portion. Florida has both types, but most of the time, clients choose the enhanced because they want all the proceeds, right? So that is a ladybird deed is if someone wants to avoid probate for real property, but they don't want a trust. The other way is to do a trust, and then we just use a special warranty deed to convey the property into the trust. Trusts avoid probate. Okay? Mm-hmm.
What if you're an investor and you have multiple properties?
Okay, wait. One and then two.
You've been specific to homestead. What if it's an investment property and the owner passed away and there's creditors? What does that look like?
Guess what? If they have not been dead for 2 years, that means that the sale is going to occur, right? We can still sell that investment property, but those proceeds are going to go into the estate bank account and creditors are going to have to be dealt with. It is not exempt.
For 2 years?
If creditors can only file claims if someone has not been dead for 2 years. After someone has been dead for 2 years, creditor claims are barred. Trusts avoid probate. So
if it's in a trust and there's creditors, they don't.
Mm,
And it's
we don't really care about creditors if it's in a trust. Okay. Of course, if there's a lien on the actual property, you got to deal with it. But yeah, if there's let's say there's investment properties and you guys, so with estate planning, most of the time if someone has investment properties, we will put it into an LLC and do an assignment of LLC interest to the trust. And we do that for asset protection purposes. But when we are dealing with trusts, I would have to tell you 99.9% of the time, credit card companies don't get paid. we're not going to go talk to them and let them know about our trust. Probate, yeah, they're going to know about it and they file a claim and then you're stuck dealing with them if anything ends up in that probate estate. But if it's in a trust or an LLC, I'm not a fan of credit card companies. I don't want to make anything easy for them. So, yes.
Last question.
Sure.
Since he was talking about creditors. So let's say, a person established a trust and put all their properties in a trust. And now someone decides to sue them because they slipped and broke their nose. So does the trust get sued?
Let's talk. So remember I just said LLCs for asset protection purposes? So now we're getting to the nitty gritty, guys. We're getting to asset protection. Probate talk turned into an asset protection talk. So what we'll do is we've got a nice little formula, and we can even get into the world of land trust, but we might not do that tonight. So if my clients have rental properties, we will deed the property into an LLC. We do not do single member LLCs in Florida because they do not offer proper asset protection. We will make one person be 99% owner and then at least stick someone on as a 1% non-voting member. And that will protect against a charging order against that LLC if there's a slip and fall and there's a lawsuit. So whenever there's rental properties, in addition to the family trust or the individual trust, that's a revocable trust. That is not an asset protection vehicle. That's a probate avoidance vehicle. But we will then put the rental properties in LLCs and then do an assignment of LLC membership interest to the trust. That's not recorded anywhere, but that just makes sure that that LLC interest does not end up in probate. Make sense? And then we do operate. So LLCs have what's called an operating agreement, and that's like the rules of how that thing is to be governed. And in that operating agreement, we'll have a schedule on the back that says who the members are, what their percentage interest is, and whether they've got voting or non-voting rights. Make sense? And let's say you get the client who wants to be anonymous. I've got a few of them. They don't want anybody, and I mean it can be a real issue because the HOA doesn't even know who they are. We will deed the property into a land trust, and there will be a nominee trustee who actually for land trust can be an LLC. So the client's name is nowhere on anything that's recorded. And then the land trust will have a beneficiary that's a different LLC. And then that will sort of through that LLC is where the client's name is, but that's nowhere in the public record. So if you have a client who wants to be fully anonymous where nobody knows they own that property, the proper protocol is to use a land trust with an LLC beneficiary for asset protection purposes.
Thank you.
And that's a little bit more complicated estate planning. Yes, Tammy?
So as agents, the problem there is, like, I had a listing where they had hired like a brother of the company that they hired to sell it, and he signed the listing agreement, and it was on the public record as this LLC owned it. And so I didn't even have a valid listing agreement because I didn't realize that he had no ability.
For what?
He didn't even own the property that I
Well,
was listing to sell as a new construction.
but who showed up as a record title owner?
The LLC. Oh, I didn't know that.
So what you do though is, okay, I want to know who owns 9 Marlin in Dolphin Cove because that property is a friggin' mess and I really would like to buy it because it looks like nobody's taking care of it. I'm going to go in St. Johns County, property appraiser. I'm going to pull up the last recorded deed. I'm going to see right there if that says LLC. If it's a Florida LLC, I'm going to go into Sunbiz. And I'm going to see if I can find out. If it's a Delaware corporation, a lot more difficult. You're not going to see much of that. You may, but probably not. But then go on Sunbiz and then you'll see at least who the manager or member is of that LLC.
And so to protect ourselves, we need to insist whoever that person is signs the listing agreement so we can make sure we get paid.
Damn right.
Right.
Yeah. And if it's in a land trust, whomever the nominee trustee has the authority to sign, and that's binding. That's binding. So if you go and do your little Sherlock Holmes investigative work, and you see, this property is owned by 912 Florida Land Trust, and then it should say who the nominee trustee is. If it's an individual, that's the person who has authority to bind. And they'll only act if they get the from direction of the beneficiary of the land trust, but that's not for you to worry about. It isn't. And it, like I said, if it's an LLC that shows up as an owner, go on to Sunbiz. Put in the name of the LLC. You should get a name. Most people are not going to be, like for us, we end up being on Sunbiz as an authorized representative for a lot of these things because our clients who want to be anonymous. Now, Chris had a question. You didn't forget your question, did you?
Kind of answer, like, if you're an investor or you got, not an investor, you have a couple of properties that are just in an LLC or something, like what happens? How do you protect yourself from that? Is everything in a trust?
So if you've got a bunch of properties in an LLC, yeah, make sure you've got your operating agreement. So Florida, single member LLCs don't afford proper asset protection because of, there's case law on this, and it's Homestead versus FTC. And that's what ended up saying that if you are a single member LLC, it is very easy to pierce and reverse pierce. So what we like to do is put someone on there as a 1%er, a 1% member, and usually non-voting rights. Yes?
Does it matter if you have multiple properties in an LLC and put it in a trust, or does each property need to be in its own LLC?
Okay, let's talk about that, and let's talk about the mechanics of how that could be good and bad. So let's say I've got a client, which I do, who's got 8 properties in St. Johns County. He wanted to do 8 different LLCs. So for each property, we did a deed and deeded the property into the LLC. Every year, he has to worry about 8 different annual reports that have to be filed with Sunbiz. Right? Yeah. And then 8 different tax returns because he's got a 1% member on he's 99 and there's a 1%. That's annoying, right? So what we've started doing, and he's not unhappy with that setup. I'm a little unhappy because he's never timely on filing his annual reports. He didn't this year, and that's a whole other story. And he didn't give us the authority to do it for him. So what we'll do at this point is we'll start, like, let's say a client has 4 properties in Nocatee and 3 in Moncrief. Well, we're going to stick the Moncriefs together, guys. So we'll shove the 3 Moncrief in one LLC, or maybe 2 of them, and then we'll try to cut it down where if there's 8 properties, we'll try to cut it down to 2 LLCs. Okay? And then remember, for each LLC, if you've got a trust, you have to do assignment of membership interest to the trust, because that is how the LLC membership interest doesn't fall into probate.
In the operating agreement?
And every LLC has its operating agreement.
You're saying you assign it to the...
No, so there's a standalone okay, so let's talk about LLCs. If you want to form an LLC in the state of Florida, the first thing that needs to be filed are articles of organization, right? I highly recommend, no need to put member on there. Member has equity. File it as a manager-managed LLC. So Florida has 2 different types of LLCs, member-managed and manager-managed. The member can be the manager, but member means equity. We really don't want to broadcast to everybody that, hey, I'm a member, I've got equity in this LLC. So we'll just put someone down as the manager, right? And that just means they manage the day-to-day operations. Okay, so that is filed with Sunbiz, articles of organization. Then the next step is, once Sunbiz approves it and it's processed, Sunbiz has come back and said that the name that we wanted was too close to another name. So I wait at this point for Sunbiz to give me the A-OK. The next thing we do is we go onto the IRS's website and we order an EIN. That is the LLC's social security number. And then right around that time, we draft the operating agreement, which spells out the mechanics of if there are partners, buy, sell, what is a buyout strategy? What if another member is going to be admitted? What needs to occur? All those rules are in that operating agreement. And then if the client has a trust, a revocable living trust, we will do a separate document that says assignment of LLC membership interest to trust. Okay? Make sense? Okay, as far as trusts go, we've been talking about the type of trust called a revocable living trust. That is not an asset protection vehicle. It is a probate avoidance vehicle, and also a great way to keep things private, right? Probates are public. Revocable living trusts are not. They're not recorded anywhere. If anyone ever tells you you need to record your living trust, tell them to go pound salt. You do not want to record that, and you don't need to. Don't ever. Don't ever. If something does need to be recorded, it would be a document called certification of trust, which just says the trust is valid, this is the grantor, this is the trustee, and whatever powers that may need to be used. So let's say you want to sell property that's in your revocable living trust. You're not going to record the trust. Title company is going to prepare a certification of trust that is going to say you have the ability as trustee to sell it. Okay? Make sense, guys? So that's a revocable living trust. While you're alive, your social security number is the taxpayer ID number. The other type of trust, which we really only use for two purposes. One purpose is for Medicaid planning, for clients who believe they're going to be going into a nursing home. And the other reason is for clients who have a taxable estate. Well, because of the big, beautiful bill, our estate tax threshold will not be changing. Estate tax, not inheritance tax, estate tax. Florida does not have a state estate tax. There's only the federal estate tax. If you are not married, when you die, you can have like $12 million without having to worry about paying a tax. Okay? If you're married, double the amount. Some of my clients are that fortunate in life where they worry about these things. For them, we will do an irrevocable trust for some of their assets. It bails that amount out of their estate. However, the IRS is I guess the IRS is kind of like how a creditor would be, where like if you can still go into that trust and change things around, they're gonna say, that's not irrevocable. You've got to give up a string of control. So irrevocable trusts, if needed, need to be drafted very carefully so that there's a back door that's left so that if things do need to be changed, they can still be changed. And that's usually through something called a trust protector. But for you guys, just so if anybody ever asks, well, should I get an irrevocable trust or a revocable trust? Unless they want Medicaid or they're going to be they know they're going to be sued very, very soon, but they haven't been sued yet, or they have a taxable estate, they don't need an irrevocable trust, okay? Irrevocable trusts they're taxed at any income is taxed at a high bracket, like 40%. So revocable trusts, any income that thing makes is taxed whatever your tax bracket is. But every irrevocable trust is taxed, like let's say it spins off income, like let's say somebody decides to put a bunch of rental properties in an irrevocable trust, whatever income that is, it's at a 40% tax bracket, okay? Make sense? So those are the two different types of trusts. You look confused. What's up?
Say, can you change it if you have irrevocable?
No. I mean, back in the day, we used to use a toggle provision, but we don't really do it anymore. Like a toggle provision would be in the case that, we don't really do it anymore. So usually if something starts off as an irrevocable trust, it cannot turn into a revocable one. Now, a revocable trust will become irrevocable when you die because you can't change it anymore. You're dead, right? So if I were to draft an irrevocable trust, there's not going to be a way for it to become revocable because it can't really be amended in the way to make it revocable. Because remember, irrevocable means you can't change it.
You can cancel it and start a new one.
That's right. But if you're doing it for tax purposes, why in the heck would you want to do that?
Because it was done wrong the first time.
Oh, no, you decant it. Decanting. Okay? Don't worry. This is where, if you guys are in a position like this, just go to an estate planner. Okay? And then they will decant your trust. So decanting means taking the messed up trust and pouring it into a new clean trust. But that's a very complicated, it can be done, but you wouldn't be doing that yourself. You'd be going to see an estate planner. Okay? Okay. So revocable trusts only, they become irrevocable when you die. Make sense? Husband and wife can have a joint trust. It'll it can become irrevocable upon the death of the first of them or the last of them. That's addressed during during an estate planning consultation on what they want. Any other questions?
Does this protect the trustee from divorce? The trust?
Well, this is a loaded question. All right, divorce. So,
Her husband's right there too.
Yeah, it's okay.
the best way to well, I'm like, the best way to handle a divorce is to do a prenup or a postnup. But I mean, if husband and wife, let's talk about that though. If husband and wife have a joint trust, they've just, anything in that trust is marital property. I think
No,
maybe.
how about if me and my brother has a trust, we're trustees, does it protect us from
Are you
divorce?
beneficiary?
Let's say me and him
Are you beneficiaries of the trust
Yes,
as well?
I'm a trustee. Let's say.
Trustees are not beneficiaries. They can be. Let's talk about
Why are
trusts,
we
guys.
the beneficiaries?
The manager of the trust is the trustee. Just like the personal representative is the manager of a will, right? The people who have an equitable right to the trust funds,
beneficiaries.
those are the beneficiaries. So if you and your brother have a trust, are you the ones who created the trust, or did your parents create the trust?
Parents created the trust.
I know where you're going with this now. Okay, so let's say clients come into my office and they have, and this happens all the time, they want to create a trust for the benefit of their kids, and they want to make damn sure that if one of their kids marries an idiot and there's a divorce, that idiot, son-in-law that they didn't like, doesn't take any type of an interest. Then what they will do is their main trust will create subtrusts. And that way, so when mom and dad die, the trust will go into the subtrust, one for daughter, one to son. And those will be continuing trusts. They don't need to go have a new trust done. It's built into the main trust. And yes, that will protect your inheritance from a divorce.
Got it.
Make sense?
Makes sense.
Okay. And that begs the
I
question.
need to do this for my daughter.
So like when you, let's say you go to an estate planner and you get a trust, and your beneficiaries are your kids. A good estate planner is going to ask you, well, when do you want your child to have a lump sum inheritance? And your answer would be never. I want it to be a continuing trust for my kid. They can still use the money for health, education, maintenance, and support, but they have creditor protection built in because they don't get that outright distribution. Other trusts say, when I die, to my son and daughter, outright, meaning whole enchilada to them right then and there. The type of trust that you're talking about has continuing trusts, and that offers for the beneficiary asset protection and divorce protection. Okay? Any other questions? Tammy.
Just from a realtor perspective, say we want to be someone who is seeking out some of those, we're driving around, we're trying to be like Bryce, we're looking at the dilapidated properties, we're like, oh man, their roof is falling in, they haven't cut their grass, I bet somebody died.
I know,
Maybe
right?
someone else
Right.
died. Not that we're hoping for that, but it appears that this property's been neglected, so we do our research with our little apps when we find out who the next of kin is or whoever the property owner is and if they're deceased or not. And then we start talking to them and we're shooting our shot basically. And hey, I know you're probably way confused and there's overwhelmed and probate and you're just trying to inherit this property and you're grieving your mom's death and there's a lot and I want to come in and help you. But they don't have any money in their pocket to even pay for it.
Yeah.
I'm going to handle probate, I'm going to handle everything. Like realistically, how much are we telling them that they need to have up front, or is everything going to get paid at close?
Well, so that depends on the probate attorney that you use. We, for the most part, depending on who the realtor is, I'd say for the most part, depending on things, we'll usually say that we'll handle all the costs of probate and we'll get paid at closing. Now, unfortunately, I've gotten burned. I had a gentleman, it wasn't the realtor's fault, I had a gentleman who ended up making that deal with us, and he decided he didn't want to sell mama's house. He never paid us. There was never a closing. So we harassed him for a while and then just plain had to write it off. So now I have to put in my engagement letter, not that I'd probably enforce it, but that if it's not sold within, 3 months or something after the judge signs the order allowing the sale, that we need to get paid. And that's because of that one guy who decided, hey, listen, I'm gonna say that I'm gonna sell it, and then once it's through probate and it's in my name, I'm just gonna stay there and not pay the lawyer. So it depends. Most of the time, we'll cover all the costs, meaning the filing fee. So a filing fee on a probate, if it's a summary proceeding that involves a homestead, it's about $346 or $351, depending on the county. If it's a formal administration, it's $405. And then probate fees, if it's summary administration, $3,000, $3,500. If it's a formal administration and it only involves the house, we'll probably do a flat rate. If there's other assets involved, then it's going to depend on what those assets are. But really, I mean, I think the worst news we get is when, well, there's a few different situations of really bad news that ends up hanging up the closing or even the probate. One of which is if we find out there's a minor involved, because we have to do a guardianship. So if one of the heirs is a minor child, there has to be a guardian, a property guardian appointed. So that's bad news. That sucks.
Because it's expensive or because of time?
Time and expensive. It's a whole other court proceeding. So like you're dealing with the probate, and then you're also dealing with the guardianship. And then you not only need to get the probate judge's permission to sell, but you need to get in the guardianship permission to sell. If it's homestead and they're a homestead heir. So that's bad news. We had a case where we did everything, and then I don't know why the title company didn't tell us. Because guess what? It wasn't just a guardianship. It was an out-of-state guardianship. Yeah, that sucked. Here I'm thinking we're ready to close, right? And then there's a minor child, and guess what? The minor child has guardianship in Michigan, but guess what? Since the property's here in Florida, we got to open up a guardianship here, but we got to get all the paperwork from Michigan. Sucked. And there are 2 kids, right? With two different moms, and so 2 damn different, yeah. That one sucked. And I'm trying to think of one of the worst. I told you about this one. Oh, homestead heirs who are in prison. And it's not the current one. I had a case in Yulee, nice house. Homestead heirs were 2 girls and a boy. So mom and dad died. It's a homestead in Yulee, nice house. Homestead heirs, 2 daughters and a son. The son is just he is in and out of prison. I always like to see what these people have done. And the last thing he got in jail or prison for is he was running around chasing somebody with a machete on Phillips Highway. Like, what? So anyway, we knew based on the liens, because this sucker had IRS liens, about $75,000. We knew that that an investor wasn't going to pay the price, and we needed a private buyer. We found one. We found someone who was going to buy that thing. We got court permission to sell it, and then guess what? The brother refused to sign. Was it Howard Smith from Landmark even drove to the trailer park when he was out of prison to see, and he's like, yeah, I'm going to sign, and then he goes, wait a minute here. I think I need to have my lawyer look at this. And so guess what? We couldn't get him to sign. It was homestead property. Doesn't matter if the personal representative, does not matter if it's homestead property. We needed him to sign. And he wasn't gonna, right? And then he went missing again, and I found out now I think he's in prison in Georgia now. So guess what happened? Foreclosed. Yep. So now, and this sucks for everybody, because what the private party was going to pay would have been enough to wipe out that IRS lien, which there were other claims, but they weren't that bad. But now there's like $30,000 in the estate bank account. That's going to be wiped up with the IRS. So these girls, they had the ability to probably come away with 15,000 to 20,000 each. Now they're going to be getting nothing, all because their stupid brother wouldn't sign. And he even had the nerve to write a little letter to the court and say, hey, I see that there's a surplus of $8,000 from the foreclosure sale. I think you guys need to send it to me. It's going to the IRS, just so everybody knows. But I'm like, dude, you like actually could have gotten money if you just would have friggin' signed. So yeah, that was a bad situation, guys. So minor children, we love them, but man, they can complicate things. And heirs who are in prison. Yeah. The other thing that can get a little tricky is if there's an heir that has capacity issues. Don't take somebody's word for it that they're the guardian. Ask for the paperwork. Custodian is not guardian, okay? Even minor children. Somebody will say, well, I'm her guardian. I'm her guardian. No, you're her custodian. You're not her guardian. And then, so just don't take their word for it. Really, I would just mention it to the probate lawyer, who should be able to then dig deep. Because your job is to be like the friendly, happy one, right? Let the probate lawyer be the bad one. It's our job to let us know about these things, and then we'll dig and try to see what's going on. Any other questions? Estate planning, probate, asset protection.
How can they find you?
Oh, me? Oh, you guys, I had fun with 2 brochures. One of which is pre-Chat GPT. The other one is post-Chat GPT. I'm not going to tell you which is which.
Emojis.
Yeah, the emojis is GPT.
You guys probably know, right? Which one do you guys think is GPT? Is that the...
Estate planning.
Yes. The other one is not.
Let me know if you don't have one, so make sure everyone...
My info's on the back. My office is in Jack's Beach.
Can I say something? You drove a little distance to get over here?
Oh no, I like coming out here.
Have you practiced in New York before?
Yeah. So I graduated from the University of Buffalo Law School in 2009. Thought I was going to stay in Buffalo, New York forever. Then my entire family moved to Florida. So I ended up practicing in Buffalo until about 2014. And then I moved to Gainesville. And then I realized Gainesville doesn't like Yankees very much. And I'm not a Gator. So I ended up doing ghostwriting for some lawyers who wanted, they didn't do estate planning, but they wanted to offer it, but they didn't want to learn it. So they paid me to write up plans. And then in 2016, I moved to Jacksonville Beach, and I've been there ever since.
So your main is real estate attorney?
No, my main is probate
Okay.
and estate planning.
Okay.
So I spend my days dealing with probates, estate planning, business law for my estate planning clients pretty much at this point, and asset protection and trust administration.
Got it.
Inheritance stuff.
Okay.
Not divorce, though. I can draft a really mean prenup, though.
So maybe I can work with you too, because our main focus is long-term care,
Excellent.
life insurance. So
Well, that's the next
Yes.
step. We need to get the mic so we can pass it around so everyone can do
Yes.
together.
yes.
Guys, ready? I'm ready to give it up.
I encourage everyone, my name's Chris, I'm a realtor and investor, and just stand up real quick, say who you are and what you do, nothing long. Start with you.
Hi guys, so my name is Lena Liu and Jimmy Leung, and we are a senior marketing director for World Financial Group, which is a Trans-America company. And we specialize in retirement planning, long-term care, insurance, and college coaching. So we do debt consolidation too, because so many Americans have debt right now. So thank you for letting me share.
They're a great company. Do you know Barb Tilga? Barb Tilga, Bill Barnett?
The Mandarin?
I think so. That's awesome.
So we do a lot of seminars too.
Hold on, ladies.
Okay.
Okay, hello, I'm Deanna Florida. I've been in real estate 8 years? 8 years? Yeah, it's 8 years. That went quick. With Coldwell Banker.
Very cool.
Hi everybody, Danielle Wolbert with Coldwell Banker. Been in real estate for 5 years.
Hi everybody, my name is Raiden. I just retired from the military. Moved here about 3 weeks ago. Own a couple properties, but just here to learn more about probate. And I'm Renan. I'm the brother of Raiden. I just work with small things. I'm just here to learn. Just tagging along.
Hey there, Tammy Baranowski. My sister and I are Jack's listing sisters with Momentum Realty. We're agents, and we're bringing our brother Will into the family business as a wallet and himself.
I'm Will. This is my sister Tammy. I do construction renovations, just about all kinds.
My name's Jay. I'm a realtor. Been doing real estate for the last 9 years. Lived in Jacksonville for 40 years. And before that, I was in transportation and logistics.
I think that's the Bryce man.
That's me. My name's Bryce Bragan. BS are my initials. No, I'm a realtor investor. I do a lot of work with Yas, love for Yas. So definitely, if you need anything with estate planning, probate, give her a call. She's great. I do business with Chris and Katie and Andrew and all the Momentum agents. So that's pretty much it.
Andrew Nebesnik, Momentum investor. Chris made me be here, so.
It does. Julius Young, Momentum Realtor, with all the other wonderful Momentum agents, and one half of the Young Group Jacks.
Hi, I'm Les Hanna, Hanna Home Services. I'm a home inspector. I also have a commercial property inspection business, so I can help you out with either one so we can assess those properties for you.
Brian Williams, and I work at Alpha Wealth Group through Prudential Advisors as well as LPL. I really nerded out about this estate planning presentation, so I appreciate that. So I've been in the financial services about the past 20 years. I'm a financial planner, so I do partner with clients around estate planning, investment strategies, tax efficient strategies, insurance, other protection strategies as well. So trying to dabble into real estate too, so that's where I'm using you guys to get help from you. So a little two-way street.
Hi, I'm Laura Williams. I'm his wife, and I'm excited to hear about all this really cool stuff. We're looking forward to investing in properties together as a couple, so it's very interesting. Thank you for your wealth of information. It's very helpful.
My name is Jeff. Sorry. Sorry. My name is Matt Oxenrider. I'm the owner of Ryder Electric. We do commercial, residential, industrial, electrical. And I'm retarded, sorry.
Jazz is amazing, by the way, guys. She's very responsive and will get the job done ASAP. She's an amazing boss babe. I'm Katie Andrioli. I'm also a realtor with Momentum and an investor as well. I'm so thankful you guys are here.
Molly Pearsall, I'm a CPA, and I'm gonna pass it in.
I'm Theo Pearsall. I'm a realtor, Pearsall Properties. But we focus on investing. We focus on finding old properties, fixing them up, and then turning them into co-living opportunities. So we're specifically focused on getting 122 doors under pad split and turning 3 2s into 5, 6, 7, 8, 9 2s, 3s. So there's good opportunity out there if you haven't looked into it.
Lacey Bishop, Realtor, United Real Estate Gallery.
Jessica Santiago Jones, real estate broker, mortgage lender. We own a property management company, and my husband walked out, but y'all can do him next time.
Irby Bovee, real estate investor, also do building, marketer. Been doing this for almost 20 years. We buy houses all over Jacksonville, so if you have anything you want to sell, give us a call.
All right, thank you, everyone. We're going to do a little raffle for our little gift card. Ms. Yasmin, can you?
Did everybody put their business card in?
Oh, you want to put it in? Slippery.
Oh my goodness.
Where is she? Where is she?
Questions?
Where did she go? Tammy, you win. You're a winner.
Gift card, a free t-shirt.
3 years of back tax money?
That's awesome. That's awesome.
Well, thank you again, everyone, for coming out. We still got leftover pizza. There's some dessert boxes as well. So we really appreciate it. This is our first time doing. We're trying to do some this often, once a month. And so we'll try to do this again in September. And next time, Katie will speak on what are you going to speak about next month, Katie? You're the guest speaker. No, I'm just joking. So we're going to, but if you got some, like, for anybody, even Jessica, if you want to speak next time, you're always open because I know you're a busy woman with all your business strategy you got going on. So we're always looking for guest speakers to speak. And
Clay likes to talk.
well, Clay wants to. So, but yeah, thanks so much for showing up. And again, take some pizza, eat some brownies or whatever we got. And thank you so much, everyone.
Thank you.
Yeah, thank you, Yasmin.
Very welcome. My pleasure.
Yeah, take it. Yeah. That was perfect.
How did it go?
I think it was great. Yeah.
Good.
Yeah.
What's your name? Jay? Jay.